Thank you very much, everyone, for being here and for that very warm welcome. I am here on behalf of the entire GLAD team to highlight some celebrations and collaborations and lay out some of the challenges ahead. It has been an eventful year at GLAD since our last dinner together, and it might surprise you to realize that 3 important legal victories centered on HIV discrimination. 30 years after the epidemic emerged, gay men still account for over half of new infections in this country. And 30 years later, discrimination remains. And so we took and won cases. Cases against an insurer for refusing to cover damaging side effects of HIV medications, against businesses for the illegal disclosure of people's HIV status, and against a New Hampshire town, which tried to shut down a group home for people living with HIV. On another front, GLAD's Transgender Rights Project went to tax court against the IRS on behalf of Rhiannon O'Donovan, a transgender woman who regarded herself as female from a very young age. She was diagnosed with gender identity disorder and followed through on medically prescribed treatment, including various surgeries. The IRS, however, denied Rhiannon's medical deductions because they simply refused to accept the legitimacy of the GID diagnosis. With a team from Sullivan and Worcester, we put on a case involving, of course, Rhiannon, her doctors, and leading experts. In a precedent-setting opinion, the full tax court, a majority of the full tax court, agreed that gender identity disorder is a legitimate diagnosis, and therefore transition-related medical expenses are deductible medical care. This year, we also won our equal protection challenge to the federal marriage definition in the so-called Defense of Marriage Act. This is a case we're litigating with 17 amazing plaintiffs in the law firms of Foley, Hoag, and Sullivan and Worcester here in Boston, as well as Jenner and Block and Cater Parks in DC. Yes, absolutely. And we also want to congratulate the team at Attorney General Martha Coakley's office who won a related case challenging DOMA on different grounds. Here in Federal District Court Judge Toro held that DOMA plainly discriminates against gay people and that it serves no legitimate purpose. The court held that the sexual orientation of a married couple is simply not relevant to the government's rules for providing Social Security benefits, joint income tax filing, or health insurance for federal employees' spouses. What is relevant under the current system is whether or not you are married, and our plaintiffs are married. Judge Toro also saw the real meaning behind DOMA, that DOMA is a national policy of federal disapproval of gay people and same-sex relationships, something antithetical to our system of equality under law. So now we're on appeal, and we're in this fight until we end the federal government's two-tiered system of marriage. I want to turn to just a few of GLAAD's collaborations in the past year. One is we argued, we briefed in the Connecticut Supreme Court a case where we argued that the court should not reduce a jury's award of emotional distress damages to a gay man in a discrimination case. And while we all know it's hard for anyone to lose a job, both common sense and research show that it is devastating to lose a job just because of who you are. We also intervened on behalf of a Massachusetts high school student, new to town, who was bullied for being gay and didn't know and therefore couldn't identify his tormentors. The school would not help, so GLAAD got him to a safe school nearby that has a great GSA. His academic performance and his happiness did a 180. And now, across Massachusetts, we have every reason to expect that the new anti-bullying law that many at GLAAD and elsewhere worked on will give the schools both the incentive and the training they need to root out bullying for good. This was also a very intense year for collaborating at the minefield known as the United States Supreme Court. In the case of Christian Legal Society versus Martinez, Hastings College of Law, a public law school in San Francisco, denied the Christian Legal Society the opportunity to register as an official campus organization. Why? Because the group refused to comply with the school's non-discrimination policy that includes sexual orientation. The group says that their members may not engage in, quote, unrepentant participation in or advocacy of a sexually immoral lifestyle, including homosexual conduct. What did they really want? The constitutional right of religious believers with anti-gay beliefs to discriminate against LGBT people across the board. In a 5-4 decision written by Justice Ginsburg, the court didn't buy it. Belief may be protected, but acting on beliefs is another matter. So there is no constitutional right from a school's non-discrimination policies. As GLAAD and the other legal groups argued to the court, those with anti-gay views have a right to speak and communicate. That's the First Amendment. But if they are going to discriminate, they can't expect help from the government in doing so.